Hello everyone, I'm Ramkishore. I'm a senior associate at AK Law Chambers, Chennai. So I'm going to be talking about one of the significant landmark judgments so far as the computation of delay damages are concerned. That is the decision of the Honorable Supreme Court in McDermott International versus Burn Standard. So before I get into the facts of this case, I would like to give a little background in relation to a certain aspects. You are already aware that one of the most common heads of delay damages that we raise in any construction arbitration or suit is loss of overheads and profits. Though it is a very common claim that we raise, there is a lot of ambiguity in relation to the methodology for computing this particular head of delay damages. Before this judgment, there is a lot of ambiguity that especially because of the scheme of Section 55 and 73 of the Indian Contract Act. That is because the basic principle to claim damages or compensation under Indian law is that you have to prove the actual loss incurred for the breach. And I think most of you are already aware that it is actually impossible to provide actual costs incurred for head office overheads. Actually strikes a balance between the scheme of Section 55 and 73 of the Indian Contract Act and usage of formulas to compute the head office overheads and profits. With this background, let's move to the facts of the case. The ONGC is the main buyer, and ONGC entered into 4 contracts with BSCL, that is Burn Standard, for covering material procurement and fabrication and transportation and installation of ED and EE jackets, piles, and decks for the purpose of ONGC's offshore construction in the Bombay High Sea in a view of achieving exploration of the production program. So, in relation to this, Burn Standard entered into a subcontract with the McDermott International, and the contract is a technical collaboration agreement where McDermott International agreed to transfer technology to Burn Standard in relation to design, construction, and operation of a fabrication yard. So, after subsequent to the entering into the contract, there are disputes arose between the parties, between McDermott International and Burn Standard, and McDermott initiated an arbitration and raised around 10 claims, as you can see from this slide. So these are the claims raised by McDermott International before the arbitrator. And one of the claims, as you can see from here, claim number 8, sorry. Claim number 8, that is for delays and disruption. They have made a claim, and this delays and disruption is particularly in relation to overheads and loss of overheads and profits. As you can see from the claims, there is a claim for delay and disruptions. So, in order to prove the damages, the actual costs incurred, McDermott International engaged an expert, and they have led expert evidence where the expert has actually looked into the books of accounts of the company. And based on that, he relied upon Emden's formula to determine the losses incurred towards overheads and profits. And in fact, if you look at the factual scenario in this matter, arbitrator in fact insisted on the production of the books of account and the other relevant documents considered by the expert. So after considering the books of accounts and the expert evidence, the arbitrator allowed the claim based on Emden's formula. So that's where the main dispute arose, and that's how it has reached Supreme Court as to whether damages can be claimed based on formula. And in relation to the computation of delay damages, these are the certain issues that arose before the Honorable Supreme Court. As you can see from the slide, that is whether the time was the essence of the contract, whether McDermott International is entitled to claim the damages for delay, whether reliance on Emden formula for quantification of damages is valid, whether the award passed is beyond its authority, and whether the award passed is contrary to the terms of the contract. So, in this regard, The Honorable Supreme Court has analyzed all the formulas that are relied upon by the arbitrator and that were internationally recognized. So before this judgment, before this decision was rendered, all we have was literature from various books, like various authorities like Hudson, Keating, Amden. And so far as India is concerned, we have PC Markanda and BS Patel. But the ambiguity in relation to those commentaries is that whether those can be the formulas mentioned in those books can be applied and claim compensation in a arbitration or any suit. So that in that context, the Honorable Supreme Court has analyzed all the formulas that are recognized internationally to calculate overheads and profits. So the first formula that was considered by the Honorable Supreme Court was Hudson's formula, as you can see from the screen here. And after analyzing the Hudson formula, they have set out what are the advantages and disadvantages. Likewise, they have considered the Amden's formula as well. And I'm not getting into how the calculation should be made under Hudson and Amden's formula due to the time constraints. But as you can see, the formula is set out here, and the Honorable Supreme Court has also recognized that it is wise. This is received judicial support in a number of cases, including Norwest Halls Construction versus Cooperative Wholesale Society Limited. And the third formula that was analyzed by the Honorable Supreme Court was Eichley's formula. The formula I set out here, as mentioned in the Honorable Supreme Court judgment. So the Eichley's formula is regarded by the Federal Circuit Courts of America as the exclusive means for compensating a contractor for overhead expenses. So far as Federal Circuit Courts are concerned, you can rely only upon Eichley's formula. But insofar as common law countries like India and UK is concerned, there is a little latitude is given. You can rely upon Hudson and Amden as well. After analyzing the formulas that are internationally recognized in various authorities, the real challenge for the Supreme Court was whether computation of damages based on formula would be in violation of the scheme of Section 55 and 73 of the Indian Contract Act. So in that context, the Honorable Supreme Court held that, see, there is no bar under Indian law to use formulas recognized in other countries. And the Honorable Supreme Court has also recognized that Section 55 and Section 73 of the Indian Contract Act do not lay down the mode and manner as to how and in what manner the computation of damages or compensation has to be made. On this basis, the Honorable Supreme Court held that though the arbitrator relied upon Hudson Amden's formula, it is not against the scheme of Section 55 and 73 of the Indian Contract Act. So, though the Honorable Supreme Court found that there is no violation of Section 53 and 73 of the Indian Contract Act and allowed the award passed by the arbitrator, there is one more finding of the Honorable Supreme Court in the same judgment, which creates a little ambiguity in relation to usage of formulas. And I've set out the passage here in the PowerPoint. As you can see, a court of law or an arbitrator may insist on some proof of actual damages and may not allow the parties to take recourse to one formula or the other. In a given case, the court of law or an arbitrator may even prefer one formula as against another, but only because the learned arbitrator in the facts and circumstances of the case has allowed MII to prove its claims relying on or on the basis of the Amden formula. The same by itself, in our opinion, would not lead to the conclusion that it was in breach of Section 55 or 73 of the Indian Contract Act. So the ambiguity, according to me, is that So the Honorable Supreme Court said that formulas can be relied upon, but at the same time, they left a lot of discretion as to in under what circumstances proof of actual damages can be insisted upon, and under what circumstances formula can be relied upon. Because when it comes to damages like head office overheads and profits, it is impossible to prove the actual loss because of the nature of the claim. So this, according to me, leaves a lot of ambiguity. So though there is some ambiguity in relation to this, but this is the first judgment which actually recognized that formulas can be used. So that is some relief to the contractors that the head office overheads and profits can be determined based on Hudson, Sundance, or Ickley's formula. And one more interesting aspect is that the decision of the Honorable Supreme Court in McDermott has been quoted with approval in another judgment, that is Associated Builders versus DDA. This is a 2015 Supreme Court judgment. I think most of the lawyers are relying upon this judgment for the interpretation of public policy, but this judgment is also relevant for uh, usage of Hudson's formula while computing the delay damages. And one more interesting aspect to note in Associated Builders versus DDA was that the Honorable Supreme Court allowed the claim where Hudson's formula was used for head office overheads and site office overheads and profits. However, if you look at the actual literature, the formula is only in relation to the head office overheads and profits. So that's all. That is my presentation. And I would like to thank Society for Construction Law and especially Gracious Timothy for giving me this opportunity. If you have any queries in this regard, you can write to me in the email set out here, and I'm happy to clarify the same. Thank you.